All right, joining me now here on the Matthew Filipowicz Show is Daniel Sheehan. Daniel is a famed constitutional law and civil rights attorney. His new autobiography is entitled The People's Advocate, The Life and Legal History of America's Most Fearless Public Interest Lawyer. You can find him at danielpsheehan.com. Daniel, thank you so much for being on the show today.
Terrific. Thank you, Matthew.
All right, so Daniel, I'm going to admit I haven't had a chance to read the entire book, but if people aren't aware, you have actually worked on literally some of the most important cases in the last 40 years of our country's history. Contra, Karen Silkwood, the American Sanctuary Movement. I'd like to actually start out with one that in terms of whistleblowers, in terms of freedom of the press, is actually really, really apt today. You actually worked on the Pentagon Papers. Tell us about your experience with that.
Well, actually, the way it started, Matthew, is I was the co-editor of the Harvard Civil Rights Law Review at Harvard Law School, and I initiated the first case that ever asserted the right of journalists to protect their confidential news sources. And that case went all the way to the United States Supreme Court while I was still a second-year law student at Harvard. And so the major law firm that represented NBC News, since it was an NBC television news person that I was representing, hired me right out of Harvard Law School to come in to be there. And we were in the process of preparing all of the briefs at the United States Supreme Court level dealing with this issue of the right of journalists to protect our confidential news sources. And while we were representing NBC in principle, we were doing the amicus briefs, or the friend of the court briefs, for the New York Times, the Washington Post, the CBS, and other news outlets. And because of that, I got to know Jim Goodell, who was the chief counsel and vice president for the New York Times. And he called me one morning and asked to have an emergency meeting at like 8 o'clock in the morning at our office, and came into our office, and we found out that they had just received the Pentagon Papers. And their law firm, Lord, Day & Lord, that represented the New York Times for the most part, had threatened to turn them into the FBI if they didn't give the papers back immediately, and said that it would be a violation of the Espionage Act if they tried to publish them. It turns out that their two senior partners at Lord, Day & Lord were intimately involved with the Nixon administration. One of them had actually drafted the secrecy laws for the administration. And so they came over to us because they had been working with us on preparing these friend of the court briefs for the Supreme Court in the journalist protection case. So that they came to us, and we had a series of meetings with them, myself, Floyd Abrams, the partner at the Cahill Gordon firm, and Eugene Scheinman, myself, were in the meetings, and we all there in the meeting decided that we were going to publish the Pentagon Papers, and from that point forward, we moved forward with them. So we got to see all 47 volumes of the confidential study that was done. We did not know at that point, at least Floyd Abrams and Gene Scheinman and I did not know that Dan Ellsberg was the source for these. But I was also assigned by the firm, in addition to doing the First Amendment defense for the New York Times, in defending, drafting up the defense for Punch Sulzberger, who was the editor-in-chief of the New York Times, for Neil Sheehan, who was the reporter that had received the documents, and also for the source, whoever that might be. So when I also was one who received a telephone call from Whitney North Seymour, who was the United States Attorney for the Southern District of New York, who contacted us in through a fit, insisting that we stop publishing the papers, and telling us that they were going to seek an injunction in front of Judge Murray Gerfine at the Federal District Court. So I was there in those hearings in closed doors with the federal judge, trying to determine whether or not to impose a preliminary injunction against us, a gag order, a prior restraint. And I was in all of those the hearings that went on all the way up to the United States Supreme Court in 13 days. So I was intimately involved in all of that, in these deep discussions about whether the Espionage Act would apply to the conduct of whoever the source was, or whether it would apply to Neil Sheehan, whether he could be charged with being a conspirator to violate the Espionage Act, whether they could go after the editors and owners of the New York Times, etc. So we were deeply involved in all of those discussions. At the same time, we were discussing the very issues of the degree to which a confidential news source could be protected by a professional journalist. So I was deeply involved in all of those cases, all at the same time, back in 1971.
Unbelievable. And again, it just, I hear you saying all these things right now, and I would like to think that we'd gotten somewhere since 1971 when it comes to these fundamental issues of freedom. And when we look at the news today, it's very, very obvious that we haven't, and in some ways, it's actually worse today than it was then. Can you compare and contrast? I mean, obviously, it's fairly historic how how Nixon went after tried to go after all this stuff. Kind of what you were just describing here. Can you describe what was the public's reaction? Because that's something that's sort of interesting to me. Because it's kind of comparing the public then to the public now when it comes to these type of disclosures.
Well, there are two major issues that distinguish the present time from back in 1971. One of them is, of course, that we're living in the so-called post-9/11 era, with the Congress having passed the Patriot Act and then later the National Defense Authorization Act, which imposed draconian restrictions on American freedoms, purporting to grant broad authority to the executive branch to wiretap telephones, to intercept communications, to sanction people who reveal confidential information, etc. So that whole era of the extreme national security state regulations that have been set forth, if you compare those to the standards that were clearly articulated by the United States Supreme Court in those various cases, you will see that they are transparently unconstitutional, those provisions. The problem is, the second problem that we're facing, however, is that, from the onset of Ronald Reagan and George H.W. Bush and George W. Bush, that there has been the appointment of very, very reactionary federal judges. The fact is, some 83% of all of the federal judges that are presently sitting were appointed by either Richard Nixon, Gerald Ford, Ronald Reagan, George H.W. Bush, or George W. Bush. And a substantial portion of those judges were handpicked by William Rehnquist from when he was serving as a special assistant United States Attorney General in the Justice Department all the way back under Ford and Reagan. And so that those judges that were appointed, many of them are members of the Federalist Society, an extreme reactionary right-wing element within the legal community. And they've been appointed to the federal benches. So that you combine the national security state kind of fervor of the W. Bush administration with all of these reactionary judicial appointments, and what you've seen is that the American news media which has become more and more dominated by conservative corporations that have bought up and centralized the news media, that they are all following the same line. They're discussing, rather than be completely outraged at the idea that the United States would torture people and arrest them with no rights to any kind of lawyers or any kind of hearings. There would have been a time back in 1971 where the people would have been totally outraged by that. But the fact of the matter is that we have been being, cooked slowly, like the frog, the proverbial frog that's put into warm water, and then they turn the heat up slowly, and the frog will just stay right in there until it's cooked. That's what's happening right now, is that the American public is being subjected to a drumbeat of national security state, indeed, one could simply say fascist mentality, insisting that we're in a state of everlasting war. It's Orwellian, actually. That the United States could pass statutes, the Congress could pass statutes authorizing the arrest of an American citizen right off the public streets, and then being renditioned and taken to a facility and not notifying anybody that they'd even been arrested. no right of habeas corpus, the suspending of what they call the great writ of habeas corpus, the right to be presented in front of a judge within 48 hours and make the state have to prove what the reason is they're holding you, and that they have to show they have probable cause to believe that you committed a crime. And that's right in the Fourth Amendment. And, to suspend those fundamental rights and refuse to allow the person to have an attorney, to allow a civilian citizen to be tried in front of a military tribunal, to be convicted by military judges by less than a majority or less than a unanimous vote of the panel, and sentenced conceivably even to death without any right to have any kind of an appeal or hearing in front of a civilian court. And to not be confronted with your witnesses. They can keep evidence secret that they're using on the grounds of its national security information. It's a travesty that has transpired here, and that I think it's because of the intersection of these two phenomena. One, as I said, the post 9/11 kind of furor that has been generated by the W. Bush administration and Dick Cheney, and secondly, the appointment of these long series of reactionary federal judges who basically think the Constitution is a ship that sits in the harbor in Boston.